Hello and a warm welcome to Federal Special Program Capital Beat. Following a series of marathon hearings, Supreme Court today pronounced its opinion advisory on whether it can impose timelines on the president and the state governors for acting on bills passed by state legislatures. Now, this was a unanimous opinion, and it was that the concept of deemed assent is alien to the Constitution. This was a unanimous opinion coming from the Supreme Court Constitutional Bench. And this opinion also noted that timelines cannot be imposed on the president or governors to decide on pending bills. However, they will take a decision in a reasonable time. Governors cannot sit on bill endlessly. If so, limited judicial review kicks in. Now, in September, if you remember, this five-judge bench headed by Chief Justice of India, B.R. Gawai, had reserved the judgment and made it clear that the center should not expect the apex court to sit idle and powerless if a constitutional authority failed to discharge its duties. Now, how do we decode this Supreme Court verdict on the president and the governors? Is it a win-win both for the center and the state? What about the federal rights? Has Supreme Court really upheld federalism? That is question number one. Or is Supreme Court seen as doing some sort of a balancing act? That's also what is a general chatter on the social media. So we'll try and answer all those questions. Joining me this evening is veteran Supreme Court lawyer and constitutional expert Sanjay Hegde. Mr. Hegde, thank you so much for joining. And my first question, of course, is that the Supreme Court has given a reason to be happy and at the same time giving enough reasons to ponder as well. How would you decode the verdict in general, what has been pronounced by the Supreme Court?
Well, firstly, it's not a verdict. It is an advisory opinion. The Constitution provides that whenever there are questions of law on which the president requires the advice of the Supreme Court, a reference can be made to the Supreme Court and the Supreme Court will give its opinion. The opinion today has been a unanimous opinion, and while it was being delivered, the judges said that they were thankful to one of their number for agreeing with the unanimity. So it also means that there possibly were differences of opinion which have all been melded to get this unanimity. So what this has basically done is to say that, look, we will not have hard deadlines. We will not tell the constitutional authorities that you will do it by this, or in default, the measure will pass without your assent. They do not want the removal of a deadline to be seen as giving a blank check to the constitutional authorities, whether it is the president or the governor. They have said that if there is undue delay, courts can still request them to finish it off within a reasonable time.
But Mr. Hegde, don't you see this as a lacuna also in this opinion and the advisory? Because there were errant governors, whether it was in West Bengal, whether it was in Tamil Nadu or Kerala, it was because the governors were sitting on the bills for a long time and they were seen as errant governors. And now, if Supreme Court says that the Supreme Court, the timelines cannot be imposed on the president or the governors, what does it go to show? And there is a certain disappointment which people feel that probably the apex court has not been able to answer on that count.
Let me just give you an analogy. Once upon a time, the Supreme Court directed a high court to hear a matter and finish it off within a week. It was again an election-related matter. It was Justice D.A. Desai of the Supreme Court who directed the Calcutta High Court single judge to do that. The judge concerned heard the matter, disposed it off, but then wrote a judgment saying, look, the Supreme Court is not a superior court to the High Court. The High Court is not subordinate. Both are constitutional authorities. And you cannot set deadlines. Thereafter, the Supreme Court has forever been saying that yes, we request the High Court to finish off the matter within 3 months, preferably within 3 months, preferably within 6 months, and things like that. The single judge who took that objection later on, Justice Sabyasachi Mukherjee, later on became Chief Justice of India. So, yes, there is a convention, or rather, constitutions work when constitutional organs are treated with respect. However, what happens if a constitutional organ just refuses to function or do? So what today the Supreme Court has opined is that yes, we can ask it to function. However, we will not set hard deadlines, nor will we assume that we can operate in the absence of that organism. Right. You cannot efface the governor out of the legislative scheme altogether. The governor has to give assent, and then the bill becomes law.
Right. No, but the kind of deadlock which was seen between the center and the state because of this, the bill's not getting cleared through. Do you think that this situation now won't arise, or there is still a chance, that the similar situation would continue?
Well, if situations like that continue, I think that what will happen is the office of the governor, or the continuance of the office of the requirement for governors, will be questioned. You see, the governor is an unelected constitutional authority.
Yes.
The voice of the people is with the elected government of the day. The Supreme Court, in a 7-judge bench in Shamsher Singh's case, said that we do not follow a presidential system. Ours is a system of parliamentary democracy. And therefore, governors have very little discretion. They are always bound by cabinet advice. Today, it has been made clear that in the matter of giving assent to bills, they may not be bound by the cabinet advice, but it can't be that they can take no decision whatsoever. That implicit pocket veto has been largely effaced. However, there won't be a deadline, nor will a deadline be used to construe that you are unnecessary to the process. Right. But if governors take it as liberty and license granted by the Supreme Court, I do think that the question of the utility of the governor's office will come to be questioned in a democracy. You must remember that the British government functioned under a system of governors. Then came the 1935 Act, under which provincial governments were elected, which were largely Indian. British governors used to stymie the process of, or whatever the Indian elected governments wanted to do. That led to that was one of the factors in the freedom struggle. And after, when we started writing a constitution, there were questions as to whether we should continue with the office of the governor. But it was said that after all, there should be somebody removed from the political maelstrom, that the governor could be friend, philosopher, and guide, and that he would only be a constitutional head. That is the point. No, any constitutional head who tries to interfere in the working of the executive, either by action or inaction, will not have the legislative backing or the will of the people as expressed through free and fair elections.
No, but ultimately, then what's going to happen is that everything again will be judicially scrutinized. Everything, their decision or the delay, if it all happens, it will again get subjected to judicial scrutiny. So ultimately, again, everything will come back to the court.
Well, if people want to fight in a civilized society, what else is the mechanism except the court? People keep speaking about judicial overreach and things like that. But if you keep coming back to court, the courts have to decide, no? And why is it that there can't be a political consensus? That yes, and that is what the Constitution envisages, that we can have only one elected government. We may have a unelected governor for ceremonial purposes and for acting as a smooth bridge between the state and the center. Just imagine tomorrow we have a president who decides that let it be whatever the Lok Sabha says. It can say it can pass any legislation, but I will not sign it. How will this country then function?
Right. But there are still certain questions, and I want to put out a tweet which has been put up by the General Secretary of the CPIM, Mr. M.A. Baby. He's a veteran politician. Nisha, if you're there backstage and if you can play out that tweet, because that's very important and some very crucial points he has raised, and I would also want you to speak up on that. Uh, Nisha, are you playing out that tweet? Yes. So here it goes. Supreme Court's answer in response to the presidential reference is deplorable and shocking. Courts shouldn't hesitate to play a meaningful role in ensuring proper checks and balances between the legislature, the executive, and the judiciary. On one hand, SC says that a timeline cannot be set for granting assent to bills. And on the other, they say that the court can exercise a limited power of judicial review to direct the governor to decide in a time bound manner. Now, who will decide what is a time bound manner? Judiciary should not absolve itself of its constitutional responsibility. Nisha, just stay on with this tweet on the screen because there are two, three questions regarding this only, which I'm going to ask Mr. Hegde. The first question is that do you think has the court hesitated to play a meaningful role in ensuring proper checks and balances between the three pillars which are listed out: legislature, executive, and the judiciary? Yes, Mr. Hegde.
There's a slightly longer answer to it, or a time
Yes,
frame.
yes, yes. Go ahead.
In the sense, what Mr. Baby is saying is essentially that the court is willing to strike but afraid to wound. And often it does happen that when courts give judgments and then those judgments are not enacted, the court has neither the sword or the purse to enforce compliance. Similar things have happened, for instance, with the collegium recommendations. If the government does not want to appoint somebody whom the collegium has recommended, the government simply sits on the file. And courts have so far hesitated to direct the government or to take contempt action against the government. While this does expose the limitations of courts, we must also examine whether governments can simply ignore courts. Or are we at a stage where governments will follow only those judgments that they like and ignore those that they do not like? Many years ago in the United States, when the Supreme Court ruled on school desegregation, that that African American children and white children would go to the same school, many of the southern states revolted. President Eisenhower, who had appointed the then Chief Justice, Earl Warren, said that it was the biggest damn fool mistake he had made. But nevertheless, after an initial thought that if Earl Warren has made his decision, let him enforce it, the President Eisenhower had a rethink and said that it is the judgment of the Supreme Court and we must enforce it. So then later, under court orders, there were federal marshals who escorted children to school.
No, but there is a certain gray area also, Mr. Hegde, and I think you'll be able to shed more light on that. Now, since it's not a judgment, you yourself said it's not a verdict, it's not a judgment, it's just an opinion and an advisory. So it is left best to the governors and the president whether to follow it or not. But of course, the timeline and the judicial review aspect is in place by the Supreme Court. So what if the governor or the president doesn't listen, doesn't follow?
If he doesn't follow, then and a government comes to court on that, the court will probably request the governor or president to do the needful. with all due expedition or with some such formula,
Right.
and may sort of keep the matter still pending at the end of 4 weeks, 6 weeks, or 8 weeks, hoping that by then the action takes place.
No, but
Now,
then that again simply.
the question is what happens if it does not take place.
Hmm.
That has, for the moment, been kept. Has not The occasion for answering that has not yet arisen.
Hmm.
It
No,
may.
but it has also led to a bigger confusion, because, like what Mr. Baby wrote, that who will decide what is a time bound manner? So, did the courts stop short somewhere? They could have specified a time period. Maybe, that could have given some kind of a closure to the case. Now, here everything is left in a to conjecture. Okay, what is the time limit? We do not know. Depends on the
it,
president. We cannot impose any timelines on them. So, it looks like a very confusing picture at the moment.
it essentially in working will mean on a case to case basis.
Okay.
The court may very well ask the governor or the president, this is what is required to be done.
No, but
This is the
allow me to
no,
interrupt you. Allow me to interrupt you. You made an interesting point. You said it is going to probably it'll be a case to case basis. Now, what if it is a case to case basis? What if it is an opposition state, which where the bills have been pending for a very long time? But yes, in case of BJP ruled states, maybe the bills will get cleared, so there'll be no floundering on that front. Then,
no, that may have very well happen in practice, but we are talking about strict legal theory.
hmm,
In strict legal theory, the governor of a state who has refused assent on a bill will possibly be asked to pass requisite orders as to why within a reasonable time. If after a reasonable time the matter again comes up and the governor has still not passed orders, maybe the governor will be asked, "What are your reasons for that?" And
hmm,
if after those reasons are scanned and if they are found wanting, the court will no doubt have innovative ways to
right,
ensure that the will of the people is not thwarted.
right. Okay, so there is a general sense, Mr. Hegde, that this is some kind of a some kind of a balancing act where at the end of the day, this opinion or the advisory has managed to give some happiness to the state, some happiness to the center. Both have something to talk about. But the big question, which Mr. M. A. Baby has raised towards the end of his tweet, that the judiciary should not absolve itself of its constitutional responsibility. So, do you also feel that somewhere, as far as the constitutional responsibility is concerned, did the court fall short on that front?
Whether it has fallen short or whether it has struck the right balance, only time tells. Right? Today, uh, today there are many who believe that the court, which should act as a brake against despotism
Right,
or against executive excess, has chosen instead to have very weak brakes or very weak controls. The problem with having weak brakes is that in case of overspeeding or any such excess, you are risking accidents.
right. So, is it a win-win then for both the state and the center? Because look at the social media. The chatter is on that it's a big win for the center, because no timelines will be now imposed on the president and the governor.
Well, tomorrow there will be different parties who may be president or at the center or a governor of a state. Then the shoe will be on the other foot. So it is time to see the constitution as a neutral, to see constitutional interpretation as a neutral exercise and not through the political prism of the day. As I told you earlier, just imagine a president of India saying, "I will not sign on legislation which has been passed by parliament." How can you have that situation?
Right.
So, what applies to the president at the center should also apply to the governors of a state.
Yes. Okay, so as you said, time will tell how this is going to unfold. But for now, yes, it seems that the governors will not be able to uh, uh, do what they have been doing so far. So let's see how it plays out. We'll have to end it here. Thank you so much, Mr. Hegde, for joining on the
Thank
Federal.
you.
Thank you.
Thank you.
Thank you.